Ndị be anyị kene m unu, asị m ka onye chiri ya zelu, asị m ndalụkwali nne kwunu si esola anyị na Eastern News 24. Asịkwa m ka Chukwu oke abịa ma gọzie na ụmụ Biafra na mgbe ikpeazụ Biafra ya na ise. Alright, ozi anyị na-ewetara unu na bụ ozi dị oke mkpa anyị ji bịa maka the update, the full details of the 13 grand charge which FG, Federal Government of the Zoo, in Mazi Nnamdi Kanu. So I will tell you ozi kabaru kun ge ya bụ ife through our own brother. You get, then after that leave us with your own comment on the comment section below, because we promise to be dropping the latest news on what is happening in Biafra land, and also any information concerning Mazi Nnamdi Kanu case update. So I see what I get opportunity where one day Biafra the Eba no Keta, what is happening now. So all right, over to you, my brother.
Federal government don't give Supreme Court 13 grounds to block the indigenous people of Biafran leader Nnamdi Kanu's release. These people, they give out notoriously to the leader of the indigenous people of Biafra. We don't see say federal government no one make anything we go release Nnamdi Kanu come quick. These people are ready to undo, and they are ready to go to any step to make sure say they keep this innocent man, Mazi Nnamdi Kanu, Onyendu, as the people they call him. They already give Supreme Court 13 grounds to block the indigenous people of Biafran leader Mazi Nnamdi Kanu's release. So anything where the Nnamdi Kanu and his lawyer they talk concerning release, federal government no ready for that kind of thing. Then just won't continue to extend the court hearing and make the matter they prolong. They go till they achieve waiting they won't achieve. Who knows before this court case can end, before this court case can actually come to an end. These people they feel find way, way to make sure say them bring Nnamdi Kanu down. And then looking at the situation on ground about Nnamdi Kanu's health issue, you go agree with me, say these people then get them some kind plans and then get some kind matter way then they plan for Onyendu, Mazi Nnamdi Kanu. On that note, we welcome once again to our YouTube platform. Yes, we don't carry another matter come. We don't carry another big matter where the trend come to you. And this one still they talk about Onyendu, Mazi Nnamdi Kanu. Do not forget that the court hearing was a few days ago, and the case was also adjourned till May 13th, I guess so. But the matter they pray be say, even though justice is being delayed, we pray that justice of Nnamdi Kanu will not be denied. On that note, make we give you waiting and this matter they talk, but do not forget to subscribe to our channel, turn on your notifications so that you too go be the first person we go get this summaristic matter we will carry come for you today. The news in details. The Nigerian federal government has added 9 grounds of appeal to the 4 it hurriedly filed last year to block the release of Nnamdi Kanu, leader of the indigenous people of Biafra, from custody. The Court of Appeal in Abuja ordered Mr. Kanu's release from the custody of the State Security Services (SSS) after dismissing the charges against Mr. Kanu in October last year. The treasonable felony and terrorism charges related to Mr. Kanu's campaigns for the secession of Southeast Nigeria and other neighboring places as the independent Republic of Biafra. Mr. Kanu, who initially fled the country around September 2017, pausing his trial that started in 2015, was apprehended in Kenya and brought back to Nigeria under controversial circumstances in June 2021. And the question wey we dey talk, why Nigerian government no fit talk the controversial circumstances wey dem take carry this man, then kidnap am, then abduct am. It's not any controversial circumstances. But we will continue with the news wey we dey sama you. The shady mood of bringing him back to Nigeria was cited by the Court of Appeal as the basis of dismissing the charges against him and ordering his release in October 2022. But to block Mr. Kanu's release, the federal government hurriedly filed a foreground notice of appeal against the Court of Appeal's decision at the Supreme Court. He then approached the Court of Appeal to suspend the execution of the order for the release of Mr. Kanu from custody pending the Supreme Court's decision on the competence of the charges. The court granted the federal government's request, allowing it to pursue its appeal at the Supreme Court while Mr. Kanu remains in custody. Having gained enough time to strengthen its appeal, the government has now filed 9 additional grounds to the 4 it filed in the wake of the Court of Appeal's 13th October 2022 decision discharging Mr. Kanu, laying the basis for questioning the decision discharging Mr. Kanu. The government said the Court of Appeal was wrong to have only considered the procedure of the indigenous people of Biafran leaders' extraordinary rendition from Kenya without examining the gravity of the alleged crime he was being tried for. Below are the highlights of the total 13 grounds of appeal on which the federal government anchored its appeal. The first one, Ground 1. In Ground 1, the government said the Court of Appeal erred in law by allegedly failing to consider the relevant provisions of the Administration of Criminal Justice Act, ACJA 2015, a law that regulates criminal proceedings in federal court. Citing Section 221 of the ACJA, the government argued that the Jumai Asanke-led 5-member panel of the Court of Appeal failed to give legal effect to the law, which stops court from entertaining preliminary objection to charges at an interlocutory stage. It added that the court's decision caused a miscarriage of justice. Ground 2. The government queried the appellate court's decision on the basis that it refused to be bound by established judicial precedent laid down by the Supreme Court on the mode of entry of defendant charged with the commission of an offense. The federal government contended that the Court of Appeal caused a miscarriage of justice when it held that Mr. Kanu's extradition from Kenya is unlawful. Citing the case of Patrick Njoven and other v. the state 1973, he said the appellate court decision was a clear departure from the precedent set by the apex court. The government further said the Court of Appeal misdirected itself when it relied on the manner of Mr. Kanu's extradition in robbing the trial court of its jurisdiction, adding it was inconsistent with the judicial precedent of the Supreme Court. Ground 3. On another ground, the prosecution said the appeal court was wrong to have relied heavily on international legal instruments and cases decided from foreign jurisdiction in arriving at its decision freeing Mr. Kanu. It contended that the court's reliance on foreign laws like the Organization of African Union Charter on the prevention and combating of terrorism, as well as the African Charter on Human and People's Rights, was at the expense of laws governing criminal procedures in Nigeria. The court below misdirected itself when it gave binding force to treaties, conventions, and foreign judgments that are inconsistent with our Nigerian legislation, the government's filing said. Ground 4. The government complained of being denied a fair hearing by the Court of Appeal. It said the appellate court justices failed to determine the competence of Mr. Kanu's preliminary objection to the competence of the charges against him, thereby denying the government the right to fair hearing. The nature of entry of the respondent, Mr. Kanu, is not relevant in the determination of the merit of the charges the government submitted. Ground 5. Contesting the court's order releasing Mr. Kanu, the government argued that the appellate court erred when it held that the federal government lacked jurisdiction to try the indigenous people of Biafran leader because of his extraordinary rendition from Kenya. There was no evidence led by Mr. Kanu before the court of first instance and the court below to show how he was allegedly abducted and rendered to Nigeria, the government said. Referencing Section 94 and the ACJA and Section 32 of the Terrorism Prevention Amendment Act 2013, the government argued that the Federal High Court was clothed with adequate jurisdiction to hear the case against the separatist leader. It further argued that the mode of bringing Mr. Kanu back to the country cannot vitiate the criminal charges of treason, treasonable felony, and terrorism pending against him. The government told the Supreme Court that the indigenous people of Biafran leader was standing trial at the Federal High Court but flouted the orders of the court and jumped bail. On ground 6, the government canvassed this Court of Appeal did not consider the issue that predated Mr. Kanu's extraordinary rendition. The indigenous people of Biafran leader, the government said, was standing trial for the commission of offenses of conspiracy, treasonable felony, and terrorism before his escape. He said the appeal to provide justice for the state whose laws and normative values were broken, and also provided no justice to the victim of Mr. Kanu's criminal act. On ground 7, the government said the Court of Appeal was wrong when it failed to consider that it was the illegality of Mr. Kanu's act of jumping bail and his refusal to make himself available for trial that necessitated his return to Nigeria. The government argued that it was under a legal duty to bring the indigenous people of Biafran leader before the trial court to answer to charges preferred against him. It explained that the trial judge, Tanyako, granted Mr. Kanu bail on 25th April 2017, but on the following adjourned date of 11 and 12 July 2017, the indigenous people of Biafra was absent from court, having jumped bail and absconded outside the country, citing Section 104 of the ACJA. The government said it was its responsibility to bring Mr. Kanu to court to face trial. On ground 8 and ground 9, the government posited that the Jumai Sanke-led panel of the Court of Appeal erred in law and occasioned grave injustice on the appellant, that is the government, when it held that the extraordinary rendition of Mr. Kanu robbed the trial court of the jurisdiction to entertain charges pending before the court even before the indigenous people of Biafran leader jumped bail and absconded. It is the contention of the prosecution that the Court of Appeal acted without jurisdiction when they entertained Mr. Kanu's appeal. They said decision of the trial court having been made without jurisdiction in breach of Section 3962 of the ACJA. Ground 10. The government argued that the justice of the Court of Appeal erred in law when they relied on Mr. Kanu's affidavit in support of the preliminary objection to conclude that the respondent was illegally brought back to Nigeria. On ground 11 and ground 12, the government also said that the appellate court was wrong when it held that the failure of the appellant to respond to some paragraphs of the affidavit in support of Mr. Kanu's preliminary objection amounts to the appellant conceding to the facts therein. The government challenged the Court of Appeal jurisdiction to entertain Mr. Kanu's interlocutory appeal, which was filed without leave of the Federal High Court. He said the Federal High Court decision, which Mr. Kanu appealed against, was interlocutory, that is, filed in the course of trial. And finally, on ground 13, on this ground, the government argued that the justices of the Court of Appeal were wrong when they relied on the alleged non-compliance of the federal government with the provision of the Extradition Act in concluding that Mr. Kanu was unlawfully brought into Nigeria and therefore the trial court lacked jurisdiction to continue the trial. And at the 13 grounds, the 13 total grounds where the federal government they block indigenous people or Biafran leader Mazi Nnamdi Kanu's release. You can agree with me that the federal government of Nigeria are ready to do and undo whatever to make sure say this man no get the freedom wey he truly deserve. How this court case go end? Now the matter we still dey ask ourselves, but don't forget say now your one and only YouTube platform where they give you the updated news. Now you carry this one come. Thank you once again for joining us. Please subscribe to our channel, turn on your notification, and definitely you will be notified whenever we drop our spanking news. God bless you and your family. Amen.
All right, thank you once again for your little time in this particular audio you just watched right now. What do you think? Leave us with your own comment on the comment section below. Don't once again forget that this is Eastern News 24, a home of latest news on what is happening in Biafra land. So the issue between the referendum, about referendum on Biafra land. All right, so what do you have to say? Drop your own comment on the comment section below. All right, once again, stay tuned. More news update is coming at Eastern News 24. Dalon linne ke mesiano. Goodbye.